Hi, hello, and welcome to my channel, friends. This is your Govindraj. Thank you very much for all your views, subscriptions, and also sharing my previous videos to all your contacts. Today, this channel has more than 4,000 subscribers, and thank you very much for all this love and support. And today, let's talk an important topic which is related to IR Code 2020, and we are going to take discussion on a trade union perspective of IR Code 2020. And if you look at today, it is being talked that the labor law reforms will create different ecosystem and generate more formal employments, but at the same time the trade unions are agitating and they are unhappy with the labor codes, and in particular on the industrial relations code 2020. And even though their long standing demand is met on the mandatory recognition of unions and their important rights related to immunity from civil suits, safeguards from the rule of criminal conspiracy, the validity of the agreement between the union and its member, even though it is restraint of trade, and while protecting the rights of the individual member, even if he does not want to bind for such agreements. So friends, let's understand and find out without taking any sides why they are agitating or why they are not happy. And again, I would like to make it very clear that this effort is to find only the facts and not taking any sides. And if you would have read the 2019 bill on IR code, it looked to me that the code is drafted by a union leader. And now if you read the final code, you will see a complete U-turn, and if not U-turn, at least you will find a serious bend from the 2019 bill to 2020 code. And the unions feel that the changes brought compared to the 2019 bill will defunk the trade union system in India, as there are many provisions which affect their interests. And some of the pro-labor recommendations of the Parliamentary Standing Committee on Labour have been ignored while making the new IR code. This is what the trade unions talk about it. And if you look at the entire IR code and even the other codes, more legislative power is getting transferred to the executive instead of legislature. Executive is nothing but the bureaucracy and the administration. The power to issue exemptions, notifications, and enhancing the threshold limits, and even to hold inquiry and award punishments and other provisions is now given to the executive, which may lead to constitutional crisis. And this fear may be genuine, as use of this power depends on which government is in power and whose side they favor. And moreover, there is a perceived threat that the capitals may use their power of money and influence the decision of executive or the bureaucracy. Now let's talk about the changes which are related to standing orders. See, the code has decreased the threshold limit of applicability of standing orders provisions to 300 workers. And this means more and more establishments will not come under the provisions of the standing orders, which covers terms and conditions of employment. And non-applicability of standing orders will give more power in the hands of employer to determine the terms and conditions of employment on their own will and fancies, and workers will suffer more and more. So that is why trade unions are agitating and they are unhappy. They are also not happy with the rules related to recognition of negotiating union as well. If you look at the provisions, the union with a 51% majority in the organization can become the sole negotiating agent. This means more possibility of having a single union, and this is felt that it is an overt attempt to monopolize a single union and eliminate all other unions. Let's also see the provisions related to layoff, retrenchment and closure. If you look at the provisions today in the IR code, no prior permissions for layoff, retrenchment and closure is required for establishments of up to 300 workers. Of course, this provision is related to factories, plantations and mines. So the union version is that it will promote ease of closing business and not ease of doing business. And let's look at the changes related to the tribunals which are brought in the code. See, the tribunals will now have a judicial member and an administrative member. So now the tribunal will constitute two members, means two members bench, which is judicial member and administrative member. So including a non-judicial member in tribunal is against the decision of Supreme Court delivered in Madras Bar Association in 2010, and this is why this is being criticized very much. And now let's look at how the awards are getting enforced. If you look at section 55 of the code, appropriate government can decide not to enforce the award where it is a party to the dispute by giving public ground or public interest reason, and this is being criticized very seriously, and these kind of provisions were already struck down by the high courts of Andhra and Madras in 2004 and 2014 as unconstitutional. But such provisions are still retained in the IR code. And let's look at how the offences are being treated today. The code has made provisions for decriminalization offences, and employers can escape from the punishment for violations by paying the monetary fine. So if you look at the code provisions, now the offences under the code can be compounded or the composition can be made, even the offences which are related to imprisonment, and this will lead to a casual approach by employers on the rights of workers. So that is why the unions are unhappy. And let's look into the fixed term employment provisions which are brought in the IR code. See, the code brought fixed term employment provisions, and if you look at the text of the fixed term employment provisions, there are no restrictions which are in place in the current law, like not to convert the permanent positions to fixed term employment and other restrictions. If you look at how the law is today on the fixed term employment, it is a settled law that a person should not be kept in a temporary or ad hoc status for long, and the management is required to fill up the permanent posts by following the recruitment procedure and not to resort appointing employees on contract or fixed term employment basis for an indefinite period. Therefore, there is a perceived threat that if the courts accept the concept without these kind of restrictions which I talked about, it will erode the permanent employments in India. So that is what union is feeling about it, and is why they are unhappy about the labor codes and in particular the IR code. And now if you look at the industrial disputes come with the applicability of limitations which was more or less unknown to industrial disputes so far. And finally friends, the appropriate government now can exempt new establishments from any or all the provisions of the code under section 85, and this is also one of the reasons for the dissatisfaction and agitations by the union. So if you look at overall these provisions and whatever I talked about it, in my view the changes to the labor laws are very much necessary considering the current dynamics and requirements of the changing society, but there could have been a little more balancing act by the code. However friends, this view is without taking any sides, and the objective, as I told you, is to give you all the union's perspective on the IR code. Thank you for watching my video. If this has enhanced your knowledge and is useful, please do share, like, comment and subscribe to the channel for more updates. Thank you again and see you soon friends.